get a lot of questions, and we talk to people all the time who really just want to understand how best to live in their very locally governed communities. And we like helping them in that regard.
That must be a little bit awkward when you're not the life of the party or people looking, weird. Tell us a little bit more about
Sure.
how things are going.
Yeah. I think what really sets us apart from a lot of our competitors is that we don't take all comers. When clients call us, we make sure that there's somebody who's going to fit in with kind of how we do business. But the important thing, I should say, what that means is that our clients do get attention. We get a lot of people who come to us from other firms where they just don't feel like they get a lot of attention because they work for lawyers who brag about having thousands of clients. And it's just not possible to pay attention to thousands of clients. And the other thing and we take a lot of pride in that, when you call our office, you're going to talk to a human being. And that goes a long way as well.
Awesome. And yes, Steve, we can hear you.
We just had a major outage here, knocked everything off the air. I'm glad you took over, Rebel. So, Shannon, what is the number one question you get from people who contact your office, from residents?
Sure. I would say broadly, the number one question we get is, can they really do that? And I guess, specifically, can they do this? And the answer to that is yes. Yes, they can. The HOAs do have liens to secure payment of assessments, and it's a very serious. So we get a lot of calls about that, and we get a lot of consternation about that. Of course, there's reasons for it. If you live in a community, your HOA is providing amenities paid for by assessment dollars. And in order to avoid the freeloading problem, the law in Texas is really everywhere. The homeowners associations, through the original developer, to impose a lien to secure the payment of those assessments so that these communities can continue to operate and provide amenities and provide services and maintain some level of standards. And the evidence shows that homes in these communities tend to have higher value than those that aren't in the restricted community within which they live. And so, yes, they can do that. Pay your assessments. It's not worth the fight because you will lose.
And another question that we get a lot of people asking about is, how difficult is it to be a board member?
In most of our communities, it's not difficult at all because we are begging people to run. It takes, there's really no qualifications required. And, we do sometimes hear from people who want who think that they need to have some special expertise in construction or accounting or law. And you absolutely don't. The only thing we look for out of potential board members is a desire to serve and an ability to put the interests of the association above your personal interests. We do sometimes find people try to get on a board of directors because they're upset about a very personal issue. The esplanades on their street get less attention than other esplanades, or they want to be able to Airbnb their home when nobody else can. And so they get on the board to try to influence those decisions. That's not a good board member. That rarely succeeds. Those are the board members who we see get removed. What we're really looking for is just somebody with questions. So if you're in an HOA and you want to see how things work on the inside, and you want to discover that it's probably not as corrupt as you think, although sometimes it is, get on the board, make change. And then you get to talk directly to your lawyers in the management company and really understand how the day-to-day affairs of these associations operate.
We just got a note from Rebel. We cannot see you, but we can hear you. Did you get that, Shannon?
Well, everything seems to be working on my end. I don't know what's happening.
You've been getting a lot of rain there, haven't you?
Yeah, but not today.
Okay, so my next question is, there you go. Okay,
I don't
now
know what
you're
happened. All
back.
right. Let's start hitting buttons.
See, that's what happens when you got a live show and things go wrong. But how much authority does an HOA have to refuse an like an ACC application?
Quite a bit. You always want to start with your governing documents and see if the declaration in particular, put any constraints on your ACC. Some are more narrowly tailored than others, but broadly, the Architectural Control Committee has discretion to make aesthetic decisions and to determine whether something that you're doing is compatible and harmonious with the broader community and with the vision for the community. So there's a lot of authority there. We don't often see decisions that we have a hard time articulating the reason for. We don't often see denials that don't make any sense. Usually it's pretty obvious why, but of course the challenge is that a lot of this comes down to personal taste. And so what you think might look great, if a whole committee of other people thinks it doesn't really look so great, then what we recommend is conversation and dialogue. Instead of threats and lawyers. So at the end of the day, there's only so much the lawyers can do when it comes to discretionary decisions. And HOAs and their committees have a lot of discretion.
Shannon, we in the area of Texas you're in, you see hurricanes every year, just about. Do you prepare your communities about what they should do with hurricane season now upon us?
On and off we do. I mean, we certainly talk to the managers that are managing these communities, and I think they're much more on the ground when it comes to things like that. From a legal perspective, what we're always very interested in is what does the insurance look like? For a subdivision, they might not be insuring much depending on their amenities, but storm coverage in Texas is expensive, and you have to make some tough choices about what you can afford. In condos, it's a really different situation because a condominium has to insure the entire structures and all of basically everything on the property except for interiors and contents in most cases. And in that regard, we want to make sure that there's decent insurance. And that's really challenging right now because there have been some big disruptions in the market, as you know, in Florida as well, for storm insurance and property coverage. And the market for insurance for condominiums is pretty terrible. Premiums have increased dramatically. It's very, very expensive, and the scope of coverage has narrowed a lot. So for our older communities, these are issues that we deal with for many, many years, especially in bad storm years, because there's damage. The insurance companies are not in the business of paying claims, so we end up fighting with them, and then their estimates tend to be wildly unrealistic for what it takes to repair things. So in that regard, we think it's always really important that these communities do everything they can to be out in front of these things, do good maintenance, do good repair, which means charge meaningful assessments to pay for all of that, which then leads to where we started. Can they really take my house if I don't pay my assessments? And the answer is yes.
Shannon, still one of the biggest topics, I can't believe this, is still about animals.
Oh, sure.
Can an HOA regulate animals
Yes,
on
they can.
a person's lot?
Absolutely. Again, look in your deed restrictions. It is very common for deed restrictions in subdivisions and condos to prohibit farm animals, pigs, chickens. Chickens are huge. And to limit the size and number of household pets that can be kept in the property. Most of the time you'll see 2 animals less than 50 pounds. It's very common. The exception to that is when you have a legitimate service animal. The Fair Housing Act and other housing laws require that there be accommodations made for legitimate service animals. Emotional support animals don't really qualify. They do under certain circumstances, but not others. And again, you should always talk to a lawyer and confer with your counsel if you've got somebody with animal issues. One thing, we want people to keep in mind is, you might call your chickens emotional support animals, but then the HOA can tell you that your one emotional support chicken needs to be in the house with you. Probably not what your intention is.
Boy, here's a great question. It just came in on YouTube. I adore your expert. This is my fourth show I've watched. I have been telling our board that they need to contact your agency. I guess they mean your firm.
Sure.
They keep telling me that we already have a lawyer, but I know they're not happy. Can you give second opinions?
Oh, sure.
Okay. So even though they have, I don't know if it's a contract, they could still talk to you, right?
They can absolutely talk to us, and lawyers and HOA lawyers in particular can be fired at will. There's no requirement that you stick with us. We can't put you under a term of years. I will say broadly, there's different rules if you're a contingency fee lawyer, which we don't do in HOA, but I don't want to give inaccurate advice. But for the typical HOA work, no, you can fire your attorney with or without cause, with or without notice. And typically we get called before somebody decides to let go their current counsel, and give us a call. We will answer your questions. We'll set up a meeting with your board, see if we're a good fit. And there's nothing preventing anybody from seeking multiple opinions from multiple lawyers.
I just think people love how educated you are in this. Shannon, what part of your practice, is it the entire practice that's dedicated to community association?
No, we maintain a commercial litigation practice, and this has been really important to me. I was trained as a commercial litigator. I started my career doing massive multi-billion-dollar, cases. That's not really the case now. Our cases are much smaller, but it's important to me that we maintain those trial skills, that we go to court, that we stand up in front of judges and juries, and we make argument. And we find that really sets us apart from some of our competitors in town who are fundamentally just debt collectors. And I don't want to denigrate that. It's important work, and it's a huge portion of what we do as HOA lawyers. But HOAs have other issues. They have disputes with vendors. They have disputes with management companies. And you should be able to look to your lawyer to offer you help in those situations. And unfortunately, we find a lot of times the lawyers won't. They're uncomfortable with it, or they can't, or they're so beholden to management companies to find them clients that they'll never get sideways with a manager. I find that ethically problematic. I don't represent the management companies. We represent associations, and luckily, we have no problem getting clients, so we don't have to align ourselves with third parties to do it.
Well, there's a reason why I brought this up. I'm really going to compliment your firm. There are a lot of firms out there. I call it the shingle. You tell people what areas of law you practice. And I see so many law firms out there that they do personal injury, bankruptcy, criminal law, and community association law. And I got to tell you, community association law is such a specialty. And I have learned from 17 years of doing this, when you can find a firm that really concentrates in one or two areas, you're going to get such better results than some attorney who just puts on their shingle that they do community association. Does that make sense?
Oh yeah, no, I completely agree. For me, that would be like, me agreeing to take on a criminal case. I don't know that law. I won't do personal injury. I don't know that law. But I do know some construction law, some real estate law, a little bit of employment, just because I've been doing this for a couple of decades. And so when those cases come across our desk, and they're usually from long-term clients, again, we want to keep our trial skills up, and so we'll take those. Because in HOA, there's just not a lot of trials. But I would say, at this point, 85% of our practice is community association law. And we work hard to follow developments in the law, to follow changes, to listen to the headwinds. And, the other thing I find is really common in my practice, before I was a lawyer, I was a social worker. And those skills I probably use more at this point than actual legal skills when it comes to helping navigate disputes amongst board members and with homeowners. And, we try really hard to also manage what becomes very emotional for people, because these are their homes. It's always hard to be a member of a collective on a board, and people just don't always get along.
Well, I saved this towards the end of our show, Shannon. I wanted to surprise you. I love surprising somebody. So we have one of the largest community association law firms for Florida, one who's been with us for 17 years. And they actually, one of the partners actually listened to your show 2 months ago. And they just contacted me about a week ago. They said, hey, your Houston Community Association firm, she is really good. She really knows the law. And they complimented you up and down. And I thought that was so cool, Shannon.
I love that. Thank you so much.
Yeah. We have a few more minutes. People have been writing us about HOA entering their property without permission. Are they allowed to do that?
Sometimes. Again, look at your governing document.
Yes.
If there's a right for self-help, it should be in there. It's not uncommon. And let me be clear. It's very different for a subdivision than a condominium. So subdivisions, you really need to have some right to self-help. Typically, that's going to be forced mow. If you won't mow your lot, you'll get notice. Sometimes it'll be for something more severe, but usually it's a landscaping thing, or to remove some signs. They should rarely enter a home. Now, if you're in a subdivision where you share walls or share plumbing and there's an emergency, there's generally a right to abate an emergency. And that would be burst pipes that are impacting neighbors and the like. Now, for condos, because of the shared ownership structure of condos and how interconnected units tend to be, there's almost always a right to enter. And in that case, it can be a little bit more extensive because of the way condos are set up and how people live in very close proximity. So you should generally expect, if you're in a condo, there's going to be a right to enter. Those entries should almost never be done without notice. What constitutes an emergency needs to be very articulable. If there's going to be an entry without notice, most of the time you're going to get notice. If it's an entry to abate a violation, just take care of it. Mow your lawn. If it's an entry to do more broad repair work, which is generally a condo thing, like we're redoing piping, we need to come in to access pipes. Work with them on scheduling, do what you can to be cooperative, but really, what you don't want to do is refuse and say no, because in the end you're going to lose. And now you're going to have to pay for the locksmith and for the lawyers and for everything else that was engaged or involved in gaining entry. It's just not worth it. And it's something to think about when you consider living in.
Shannon, can an HOA, and we have to let Shannon know if you're an HOA or a condo, can an HOA keep you from renting your house?
It can. Again, governing documents are key.
When in doubt, go to the docs, right?
Always start with your documents. But this is really becoming a big deal with short-term rentals, and it is because new developments are almost universally that we're seeing putting in restrictions on short-term renting. Rarely do people want to live next to that. And in a lot of established communities, we're seeing amendment votes being undertaken to impose short-term rental restrictions on properties. Those are valid. If the amendment was validly passed, the Texas courts have held that that is enforceable, even if you bought your house or your unit in that association thinking you were short-term rent, and the rules change, the amendment passes, you have you're not grandfathered. And in some communities, depending on the way that the deed restrictions are written, the board can implement these types of restrictions. So it really is specific to how your documents are written. But as a broad answer, yes, they can absolutely restrict renting. You can impose rent caps where there's a limit on the number of units or homes in a community that can be rented. You can be required to lease only through the management company and pay a fee to do it. It really comes down to what's in the documents. So we encourage everybody to read these documents before you purchase, and virtually nobody does. We get so many calls from people who express surprise that they've got deed restrictions, and we tell them, well, did you read your title commitment? And they say, you're what? We're like, that's the document the title company gave you that said, here are all the things that you should be aware of. And rarely are they read. So read them. In Texas right now, there's a requirement that we post something called a management certificate on a public-facing website called HOIA.texas.gov. And you can look those up by name of the community, and they will include the file number for the declaration. So if you can't find your deed restrictions on a public-facing website, you can go to the public-facing county property records, type in that file number, and look at your documents. We strongly encourage people to do that. Always start.
Shannon, tell people how they can reach your office.
Sure. We can be found on the internet at shannonlanglaw.com, and you can call our office, 832-479-9400. As I mentioned earlier, we take great pride in the fact that we actually answer the phone. There's no phone tree. There's no recording. If you get our voicemail, it's because everybody in the office is on the phone, and we will call you right back.
Shannon's with us every month. Shannon, we'll see you next month. Thank you again. You've always got such great information, and I'm glad I could share that surprise I had for you.
Thank you. I really appreciate that.
You're the best. Thank you, Shannon. We'll see you next month.
Terrific.
That's Shannon Lang of Lang and Associates. That's going to do it for us today. We'll be back again with you next week with more Ask the Experts.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.